If you go back to the Constitution, you have Article 1 dealing with the legislature, Article 2 dealing with the executive branch, Article 3 dealing with the judicial branch. And even though we're told that they're co-equal branches of government, people have made the argument that the legislature should be more powerful, the executive secondary, and then the courts tertiary, in a sense, as far as power structure, the amount of power that they each have. And yet, to me, when I look at the current state of affairs in our country right now, it seems like somehow the courts have so much power, almost like a tyranny, so that if an executive order is given, the courts can now become experts on immigration policy, and they can deny something that takes place. And again and again and again, these things take place. To me, it almost seems like there's a tyranny of the courts, and it might be nice if they were beneficent and just, but I don't think that many people think that the courts are always just. That there's a little bit maybe of corruption in there. Can you talk a little bit about that whole topic, perhaps?
That's one of my favorite topics, actually.
Okay.
Is how did we get here to this place where there's rampant corruption in our courts? Mm-hmm. That justice is for sale. How did we get to this place? And Thomas Jefferson knew that this would happen. Mm-hmm. In 1821, he wrote a letter to C. Hammond, and this is in the National Archives. And in that letter, he said the dissolution of our government is in the power of the judiciary, mm-hmm. an irresponsible body, working like gravity, by night and by day, gaining a little today and a little tomorrow, like a thief over the field of jurisdiction. Key phrase there, mm-hmm. like a thief over the field of jurisdiction, until all shall render powerless the checks of one branch over the other, and shall become as venal and oppressive as the government from which we separated. And venal is defined as justice for sale. Mm-hmm. And that's what our courts are today. So in 1821, Jefferson knew that this would be a problem. When we talk about the judiciary only is granted judicial power. Mm-hmm. That's their only power they have.
They don't make policy.
And judicial power is to decide cases at controversy. That is their only power that they have. But like Thomas Jefferson said, like a thief over the field of jurisdiction. So how this happened, and a lot of this information, this is a book. It's by John Fitzgerald Malloy. It's called The Fraternity, Lawyers and Judges in Collusion. This book was endorsed by Senator John McCain, by the President of the American Society of Criminology, by U.S. Secretary of Interior, and by Ambassador to El Salvador, Bolivia, and Argentina, as well as other dignitaries. Mm-hmm. So this is a well-respected judge, John Fitzgerald Malloy. He's one of the few judges that I still refer to as honorable. Mm-hmm. He said how this problem started out. In 1949, lawyers made about as much money as a plumber, and they had about the same education level as a plumber. And the billing practice of the legal profession at the time was based on the service that they provided, okay. What the client could afford to pay, and what the client thought they should pay. So
it wasn't necessarily an hourly billing rate then?
Say that again?
It was not then an hourly billing rate?
Exactly.
Okay.
And it was a fair billing system back then.
You knew what you were going to get, and you knew what you're going to pay for it.
Yeah, and then
up front.
Yeah, and so what they started in the 1960s is where they came out with the time is money concept. Okay. And that's where they started billing in tenths of an hour or 6-minute increments. So okay. You call an attorney now, they start the timer. They all have software for it on their computers, and they pick the client, and they start the time. So you're paying for every phone call, every email, and it adds up, before you know it, $10,000 is out the window, and you haven't even been into court yet.
Right.
So once they started that time as money concept, Judge Malloy said in his book, the time that it took to get things done extended wondrously.
Wonderful. Yeah, exactly.
Yes, wondrously. And these guys started making money, and they liked it. So then they started complicating the process by introducing rules of procedure and making the process
And it's wondrous.
making it more complicated. And what Judge Malloy said,
And they wrote the rules to make it more complicated.
exactly, and what Judge Malloy said was to make less what lay persons could do for themselves. So as they made this process as complicated as they could, they're still hungry. They want more money.
And now we need to guide you through these murky waters.
So their next step is creating new torts. And these judges agree because they're attorneys too.
Right.
And so, then you end up with things like the McDonald's coffee spill case. Our economic theory when we founded this country was caveat emptor, buyer beware.
Mm-hmm.
We have completely flip-flopped that economic theory to product liability now. It's the manufacturer's responsibility to sell safe products instead of the buyer's responsibility to be a smart buyer. And there are some advantages to product liability
mm-hmm.
and holding businesses accountable. I won't dispute that, but the fact of the matter is that these new torts were created. They were new product lines for the legal profession, just the same as a car manufacturer introducing a new line of cars.
Mm-hmm.
It's exactly the same thing. So what happens now? Okay, so we've complicated this process as much as we can. We've created as many torts as we possibly can.
Now there's got to be some more new income streams, right?
Right. So the next step is vexatious litigation.
Here we go.
So now let's start suborning perjury, and let's work with our attorney friend who happens to be wearing a black robe, and we're going to introduce this perjurious testimony or these unsupported allegations. And you, judge, are going to go ahead and rule in favor of those unsupported allegations because we know this poor guy over here is going to fight like hell for justice.
And more money coming in. We're all rich.
And that's what it's about, is generating billable hours. And so the result of that today is not just the vexatious litigation, because in order for those unsupported allegations to survive, what do you have to do? You have to avoid due process. Because if you have due process, those unsupported allegations are not going to be used as a basis of decision. So now you've got to get in, when you prove that perjury, they ignore the perjury because they don't want to dissuade future perjurers.
Yeah, exactly.
They don't want somebody going,
man, if we get rid of that perjury, we're going to lose a lot of money.
Exactly. And so perjury is almost never prosecuted.
Right.
And that is a denial of equal protection of the law, because it's a crime in state and federal statutes to perjure yourself in a court of law.
Yeah. It's on the books anyway.
But the courts will almost never enforce perjury statutes. Right. So we went from complicating the process to introducing new product lines to rights violations and vexatious litigation. What's the next step?
Okay, before we go there, I just want to make a comment about this. There was a man that running for judge, and I was saying, why don't we prosecute perjury? And his response was, our courts are already crowded right now. Do you really want me to prosecute perjury when I could be, and this is what he said, when I could be going after a man who's raping a teenager? And I said, well, wait a minute here. First off, you take the worst possible scenario. This is what you're using for the comparison. But don't you think if you started to prosecute perjury, if you put 10 people in jail, that the word might get out that perjury is no longer acceptable? And everybody would say, well, let's stop this. Maybe you would reduce your court load. He said, well, that's a good idea. But anyway, to continue on, it is
absolutely ridiculous.
Should we prosecute perjury? Is it really that important? I have a conversation recorded. But I'm sorry, you were going someplace else.
Here's the problem with it is when a person is denied justice, that's a betrayal of their government, who they trusted. And the symptoms that result from that are exact same symptoms of rape.
Oh, absolutely.
Disorganized thought, helplessness, obsessive thinking about the crime that was committed against you.
It is rape, but just not a physical rape. It is rape.
It is the exact same mental infliction of anguish that happens from rape.
right.
happens from being denied justice in our courts.
Yeah.
It is exactly the same symptoms.
It's not merely being denied justice, but often you get punished.
So
anyway.
that would be what I would tell that judge.
Yeah.
Is the victim of rape is just as harmed as the victim of perjury.
Right.
Because it's that denial of justice, it's that betrayal
Yeah.
of walking into a courtroom thinking you're going to get a fair shake, when actually the court and the attorneys are all conspiring against you.
It's like telling the rape victim, oh, you probably deserved it. It must have been what you were wearing. It must have been the way you walked. You didn't portray enough confidence. Yeah. So now not only have you been raped, but you are also guilty of being the provocateur of the rape.
Yeah.
I mean, it's crazy.
And that's the same feeling that you get when you're in these courtrooms and they ignore the perjury. It's a huge, incredible problem in this country. The corruption that is occurring in our courts. Now, in order for all of that to transpire, that judges are colluding with attorneys, which there's no doubt. Judge Malloy talks about lawyers and judges in collusion. This was a confessional. Judge Malloy was the Arizona appellate court judge who was involved in the Miranda v. Arizona case, which is where we have the Miranda rights evolved from. He clearly recognizes that this, and he does this as a confession, that this is what our legal profession has evolved into. And not just Judge Malloy, Chief Justice Berger, he said, if we do not do something to provide an alternative for courtroom proceedings, our nation is going to be overrun by lawyers, hungry as locusts, and brigades of judges in numbers never before contemplated. Chief Justice Warren Berger. Now, that was 1971.
Yeah,
1971, I think he said that, speaking at a law conference.
An explosion of...
So that's where we are today. Is see, you've got all these attorneys that pay incredible amounts of money to go to law school. Very expensive, huge student loans. And you've got all of these mouths to feed in the legal system, and they have to perpetuate that vexatious litigation to keep this system from falling apart. I believe it's a house of cards.
I was going to ask you that very same question.
That once we remove, we talked about this in another segment, that if any oversight agency or function were working, that this corruption couldn't occur in our courts.
Right.
If the FBI was doing their job, judicial oversight agencies were doing their job, if the legislature had not abrogated its authority to impeach judges when they transferred their power unconstitutionally to these judicial oversight agencies, if anything was working, if the federal courts enforced federal statutes, 18 U.S.C. section 241, 242, any person who injures or oppresses a right is subject to fine or prison, but it's never prosecuted.
Right.
And under 42 U.S.C. section 1983, 85 and 86, any person who violates a constitutionally protected right under color of law is subject to civil suit.
Right.
But the fact that it's happening is prima facie evidence that not a single mechanism for oversight is functioning. Not the media, not law enforcement, not our federal courts, not judicial oversight agencies, not even our legislatures.
Yeah. But there's an excuse that accompanies that. We have much more important matters than protecting your constitutional rights. This is what they say. This is exactly what they're saying. Do you really want us to spend our time, waste our time and money and energy protecting your constitutional rights when we have all of these hideous, horrible crimes going on over here? We should be focusing on this. Your constitutional rights don't matter.
Well, what I hit home when I've sat down with 30%, over 40 members of the House and Senate for the Tennessee General Assembly, and when I present this problem to them. I hope you guys will go back. We're gonna do another segment on remonstrance, and you have to watch that. This is how we're gonna heal our country. But when I sit down with these guys, I tell them, you have an opportunity before you, like no other legislature in the
Absolutely.
history of this nation. You have an opportunity to begin a great healing.
Right.
And if you have the courage to do the right thing today,
Yeah.
other states are going to follow.
Right.
And when that happens, there's going to be a great restoration of justice back to our courts.
Absolutely.
And you're going to save lives for generations to come.
Right.
If you have the courage
If you
to
have
do
the
the
courage to
right,
do it.
if you do the right thing today.
Yeah.